signal chats, all of that kind of stuff, and they're not getting it. Now, what's interesting is some of this communication, which we'll get to, and I should probably stop talking about and just get into it. They've got this stuff, they're just not turning it over, which is kind of interesting. So let's get into it and do my pen. Okay, cool. So again, this is going to be a motion to compel, which means they're asking the judge to step in. Can you do something about them not giving us the information that they're required to give us, but they simply just don't want to? So order compelled to defendants of Olson, both of the Olsons, in response to their written discovery. The court ordered on February, wow, so this is all the way back on February 26th. This motion is made pursuant to the federal rules. Compulsory filed by WFG administration motion to shorten the time. So they also want to cut it down because in the original expedited discovery, they were supposed to have this in like 5 days, and they haven't gotten any of this information, so they're asking for some help on that, and this document kind of goes into why. So they're going to do a little bit of background. We'll talk about the expedited discovery, their responses, so we'll get to see exactly what the Olsons are saying and why they don't want to turn over this information. That they've attempted to meet and confer with the defendants, and they still haven't been able to get any information. That the defendants are basically putting self-imposed subject matter and certain limitations on the data, which is kind of funny when we get into that. Some of the objections that they have on why they don't want to turn over all of this information, and then also that to this point, WFG has received no documents from the defendants, and they're saying that the objections that they have should not be founded. So kind of dive through, there's a bunch of case law there, obviously. So they want to compel the defendants to be able to comply with the court's previous order directing the defendants to respond to WFG's written discovery and produce documents. The parties have met and conferred in an effort to resolve any issues relating to the court order discovery without any need for further intervention. Both parties have reached an impasse. So the two of them have been talking, and they simply cannot get this information. So the court granted them to be able to get discovery, so the court has already said that this is okay and that they can do it. And so they're basically just talking about some of the rulings as far as that goes. And so WFG has served its written discovery as approved by the court and the defendants counsel on the 28th. And they're kind of just rehashing some of the things, saying, hey, judge, remember you said that we could get this information? Because remember, the judge has got a lot of things going on, so they like to remind him of what's going on and kind of the time frames. So then on March 6th, they tried to serve them, and they evaded deficient discovery responses and did not produce a single document. Defendants refused entirely to respond to any of the 4 interrogatories, and one of the 4 RFPs served to them respect to the others, despite the court expressly finding that WFG discovery was narrowly tailored. So narrowly tailored just means that it's appropriate, right? Like if you do something in 2023, you shouldn't be able to get information from somebody from 1995, right? Like it needs to be defined within the scope of what we're actually looking for. And you can't just go through somebody's complete history. It's got to be narrowly tailored, which they did. The defendants responded that they would only produce documents subject to the unilaterally dictated limitations. To date, despite the parties' meet and conference discussions, and even in response to additional successions, so basically successions means that they're giving up some ground. So maybe they were allowed to get all of this information, and they go, okay, well, you're right, maybe we don't need some of this and we don't need some of that, so let's kind of meet in this area. So they're kind of narrowing down the information that they're able to get. And so they're saying, hey, we've given up some ground here, we're working with these people, we're trying to get the information, but it's still not happening. So they're trying to resolve the disputes. Defendants have not produced a single document, nor have they provided any subjective response to any of the interrogatories. So here again, as a reminder of what they're asking. So interrogatory, they're asking to identify all current and former insurance agents of GFI, including the date when they first became insurance agents of GFI. And this is important, right? Because when they started also can be checked against when they left WFG, because the issue here is not that they left. Remember, people can They're free to do what they want. However, you're not supposed to sit the fence and be with two companies at the same time, especially if you're moving agents and clients over. So they want to know, when did they first start with GFI, because we want to compare it to when they left to WFG. Okay, and what the defendants, the Olsons, are saying to that is, well, based on these objections, it is not relevant to the alleged breaches of contract based on the confidentiality and non-disparaging provisions, which are the only issues for which this court is considering expedited discovery and will not be provided as a response to this interrogatory. So they're saying we don't have to turn this over, because if you remember, their whole real debate, or the whole legal stance that the Olsons have, is that California Code 16600 says that you're not allowed to have non-competes or non-solicitation clauses, right? So they're saying since this has to do with solicitation, we're not turning that over because the California regulations should say that shouldn't even be appropriate. So we're not even talking about that. And since this has nothing to do with disparagement, right? Like a agent moving over their timeframes has nothing to do with disparaging the company or alleged breach of contract. That would only have to do with the non-solicitation. So you can see they're kind of playing on words here, right? They're like, this doesn't have anything to do with the agents because it doesn't say anything about non-disparagement, so we don't need to turn this information over. Since they kind of in their mind already ruled that what they're doing is legal, that they can take people over to this other company and they can solicit both agents and clients. They already saying, well, that's fine, so we don't need to turn information over according to that, because according to the California statute, you're not allowed to have a non-compete clause. All right, the interrogatory 2. Identify all confidential information or property that you or persons affiliated with you have retained since your departure from WFG, and identify any persons with whom you have shared such confidential information or property. So again, this is going to be things like, did you print out sheets of the top performers? Did you print out some of the leaders' bulletins so that you know who to target? Did you bring over client information? What kind of confidential information do you have? And their response is that WFG is referring to Olson's forthcoming expedited document production. So they're saying, well, it's kind of already on its way, so we're just not in a hurry to do that. Interrogatory 3, identify all communications and statements made by you or persons affiliated with you or GFI concerning WFG, its future ability to stay in business, its compensation structure, or its opportunities. Did you say anything negative about the company on your way out? And they say, well, based on these objections, Mr. Olson declines to answer this interrogatory at this time. I don't know if this is the same as pleading the fifth, but it sure feels like it does. They're like, I just don't really want to answer that at this time, so thank you very much. We're not going to give you the information you want. And then number 4 is identify any customers with whom you previously worked while engaged with an insurance agent of WFG, or whom you or anyone in your downline have communications with since you left WFG, and state the nature of the contents of each of those communications. And their response to that is, based on these same objections, Mr. Olson refers plaintiffs to any documents reflecting communications with customers that may be produced in response to the request for production. 2, that extent may or may not, they're saying to the extent that any may exist. So we're not saying that any of this exists, but if they do, you'll get it with this other request. All right, is this follows the chart written discovery? Okay. Number 1 here, all documents and communications related to the evidence of the creation of GFI, its independent contractors, its agreements, and its registration. Their response is, based on these objections, Mr. Olson will not respond to this request at this time. So we don't feel we need to turn these documents over. Number 2, all documents and communications relating to your use or profession of confidential information or property, including but not limited to WFG's compensation structure, hierarchies, contracts with providers, etc. Based on the foregoing objections, Mr. Olson will construe this request as asking him to produce documents relating to his use or possession of confidential information following his termination from WFG. Furthermore, Mr. Olson will construe that the phrase confidential information to exclude the names and contact information of WFG agents, emphasis on the original, second emphasis on added. So basically what they're saying is I don't need to turn over the information until after I got terminated. And if you can see how, I understand it's a game, right? And we're playing offense and defense here. So his defense here, I guess, is that, well, I'm not required to turn over any of the documentation prior to me leaving, which would include the starting of GFI, which would include talking to the people who came over and all of those things. He's saying, well, I only have to turn this over following the termination of WFG. So they're trying to put a line in the sand that we don't want to give information from before the termination, but we'll give you the information after the termination. WFG's gone, no, that's not what we said. We need to know what happened before as well. Number 3, all documentations and communications reflecting all statements you have made or caused to be made about WFG, its compensation, its business practices, its financial viability, its opportunities, its leadership, or its independent contractors. Are you saying negative things on your way out as we've seen through Bosley and a lot of the other testimonies? They were saying negative things and things that were inaccurate, Thawley coming over, that kind of stuff. And so his response is, based on the foregoing objections, Mr. Olson will construe that this request asked him to produce communications in which Mr. Olson reached out to WFG agents after he was terminated, and which he discussed WFG, its compensation, business practice. So again, he doesn't want to do September, October, November, December, till basically the end of January. He doesn't want to give up any of that information of all the people that he recruited then, but he said, okay, I'll give you the information after I was terminated in January. And so kind of, they're trying to split the baby on that and say, we'll give you some information, but we don't want to give you all of it. And number 4, all documentations or communications reflecting or evidencing your or persons on your behalf communicating with current WFG agents, their spouses, or their family members concerning GFI or the possibility of becoming affiliated with them. And his response is, he will construe this request as asking him to produce communications on which Olson reached out to WFG agents after he was terminated. So basically, once he was terminated, he stopped reaching out to people, right? Because once he knew kind of the lawsuit was going on, well, then that communication might be very different than all the communication he had prior to getting caught by WFG for recruiting all of these people. So he's kind of saying, okay, well, we'll give it to you after I was terminated.